Tonight, on a special edition of 2020.
Terrifying home invasion.
An admittedly stupid thing.
The teenage suspect,
17-year-old,
faces a charge of
confession.
Deceased.
charge in her death.
Accused of murder.
Given the death penalty,
capital punishment.
The suspect is behind bars.
Has been found guilty.
In St. Louis, Missouri, a reckless 17-year-old boy, an innocent woman, and a cold-blooded murder. In 1993, Christopher Simmons, at age 17, planned a vicious burglary leading to the murder of an innocent young woman named Shirley Cook. He broke into her home, bound her with duct tape, drove to a bridge, and threw Shirley over the edge into the river below. Simmons willingly confessed to the murder and even bragged about his immoral actions. He gave a videotaped reenactment of the murder. The jury found Simmons guilty, and he was sentenced to the death penalty in 1997. The United States, a nation of proclaimed superiority, shows judicial inconsistencies. Is the death penalty a united national concern, or should each state have the right to decide for themselves? The case of Furman v. Georgia highlights such American insecurities by questioning whether the death penalty infringes on the 8th and 14th Amendments. Does the world community have the authority to question the use of the death penalty within America? While it could be argued that the case of Roper v. Simmons is merely a national issue that should not be subject to international opinions, it could also be reasoned that the United States is obliged under international laws as a prominent member of the international community. On one hand, one could argue that the United States, under state sovereignty, has the right to decide which international laws and customs they observe. Whether the death penalty is deemed against the 8th and 14th Amendment is an American concern, one which should not be forced to fall in line with international standards of morality. On the other hand, the United States is expected to follow international treaties based on customs of reciprocity, cooperation, and international stability. For instance, the Vienna Convention outlines the law of treaties, and although the United States Senate never officially ratified the treaty, the nation follows the treaty based on an understanding that the provisions are already customary international laws. The Roper v. Simmons case, though not international in nature, highlights these contentious arguments. Is the United States subject to international laws at all times, or only when convenient to do so? There are cases that can be used to argue both sides of the debate. The Legrand case, Germany v. United States, can be used to interpret both sides of the issue. Germany filed a case against the United States in the International Court of Justice when the U.S. breached their obligations to Germany and executed their citizens. The ICJ ruled that American actions were a breach of their obligations under the Vienna Convention. Formally, the Legrand case obliged the United States to follow international laws based on the ICJ decision, whereas, in practice, the case can be used to illustrate the argument that the U.S. has a sense of supreme authority within the international community.
We are Americans, and the future belongs to us.
Their refusal to give authority to the rulings made by the International Court of Justice makes this opinion irrefutable. Similarly, the 2008 case of Medellin v. Texas also argues against international involvement in United States legal concerns. The defendant, Jose Medellin, appealed his death penalty sentence on the grounds that it did not comply with the provisions of the Vienna Convention. In response, the court ruled that the U.S. Constitution does not require American courts to uphold obligations made under international treaties. Cases can be found to prove both sides of this debate, making it a controversial international topic that remains prominent. Specific to the case of Roper v. Simmons, Simmons won his appeal, and it was determined that anyone under the age of 18 could not be subject to the death penalty following evolving standards of decency. In terms of the contentious discussion of international obligations, it is hard to say definitively where national interests trump international interests. In the United States, they follow their obligations when convenient and on a state-by-state basis. To the rest of the international community, it is universally believed that nation-states should be required to follow international laws concerning basic human rights, such as life or death.